Before we start with the tutorial, we would love to hear your views about today's topic or our tutorials in general. We appreciate the impact we have on your studies, and we wish to learn how we can improve our tutorials for you. Introduction to Law 202 Presence. Administration of Deceased Estates. What are deceased estates? A deceased estate comes into existence when a person dies leaving property or a document, which is a will or purports to be a will. Such estate must then be administered and distributed in terms of the deceased will, testate deceased estates. Or failing a valid will, in terms of the Intestate Succession Act, 81 of 1987, intestate deceased estates. The procedure which must be followed to administer a deceased estate is prescribed by the Administration of Estates Act, 66 of 1965. What are deceased estates? Which death must be reported? The death of a person who dies within the Republic of South Africa and leaves property or any document that is a will or is intended as a will, and the death of a person who dies outside of the Republic of South Africa, but who leaves property and or any document that is a will or is intended as a will in the Republic of South Africa, must be reported to the Master of the High Court. Misconception about administration of deceased estates. The expression first come, first serve has acquired new meaning when we are dealing with the appointment of executors in deceased estates. There are in many instances the erroneous perception that the person who is appointed first as executor will be entitled to the proceeds of the estate. Most of the disputes in relation to the appointment of executors in matters of succession originate from disputes over a variety of family law and succession law topics. Testate deceased estates. Letter of executorship. The master has the authority in terms of Section 14 of the Administration of Estates Act, 66 of 1965, to appoint nominated persons as executors by any deceased person in a will which has been accepted by the master, and to issue letters of executorship to such a persons. The master may make an appointment and grant letters of appointment under Section 14 if the deceased has executed a will and the said will has been accepted and registered by the master. The Act recognizes and enforces testamentary freedom. It envisages that where a testator has nominated a possible executor in the will, absent any grounds of disqualification recognized in law, then the master is obliged to appoint such a nominee. Intestate deceased estates. Letter of executorship. Section 18(1) of the Act deals with the master's authority to appoint executors in proceedings where a deceased person failed to nominate any person in his will to be his executor. When a person died without a will, the master has the discretion, in terms of Section 18, to appoint a person which the master may deem fit and proper to be an executor. Letter of authority. Section 18(3) deals with where the value of an estate does not exceed the amount determined by the minister by notice in the Gazette, authorizing the master to dispense with the appointment of an executor and give directions as to the manner in which such estate shall be liquidated and distributed. The minister determined the amount referred to in Section 18(3) of the Act in Gazette number 38238, dated November 24th, 2014, in the amount of R250,000-00. Section 18(3) clothes the master with authority to dispense with the appointment of an executor if the value of the estate does not exceed the threshold, and that the master may direct the future manner to liquidate the estate. The master, when deciding to act in terms of Section 18(3), may appoint an executor if not nominated by the deceased, and exercises a discretionary power in appointing such executor. Nature of the master's power and functions in deceased estates. The master is clothed with the necessary administrative power. Failures of the master to follow the procedure provided by Act 66 of 1965 to make the appointment can result in an error of law. The public is entitled to rely on the master to scrupulously observe the provisions in the Administration of Estates Act 66 of 1965. It is by acting fairly within the confines of the law that the confidence of the public is fostered and maintained. The primary function of the master is to regulate the administration of estates. Functions of an executor. In our law, the executor is the person in whom, for administrative purposes, the deceased estate vests. No person may liquidate or distribute the estate of any deceased person except under letters of executorship granted or signed by the master. Executorship is a sui generis office, a special office. It is the duty of an executor to liquidate the estate of which he has the administration as speedily as possible. He must promptly pay all debts and legacies due by the estate, and for that purpose, if funds are wanting, he must realize some or all of the assets of the estate, as the case may require. It is his function to take all such steps as may be necessary to ensure that the heirs in the estate to which he is appointed receive what in law is due to them. The functions, duties, and liabilities of an executor is derived from the common law or as set out in the Act. The executor has residual common law powers to exercise his fiduciary duties, to act in the best interests of the estate and the beneficiaries. He is obliged to take control of the assets, preserve them and administer, and wind up the estate as speedily as possible. 1. In the event of conflict between the beneficiaries, he must seek direction and approval from the master in the event of the beneficiaries not being in agreement. The master plays an oversight role in relation in such disputes. The executor is the only person who can sue on behalf of the estate to recover damages for harm caused to estate assets and for vindication. Executor and beneficiary locus standi. As a general rule of our law that the proper person to act in legal proceedings on behalf of a deceased estate is the executor thereof, and that normally a beneficiary in the estate does not have locus standi to do so, the discretion of the executor cannot be interfered with simply because of the conflict existing between the executor and the heirs to the estate. Beneficiaries, however, can be clothed with the locus standi in exceptional circumstances only. Exceptional circumstances arise in instances when the executor is delinquent and can therefore not challenge her own conduct. In these circumstances, the beneficiaries can institute proceedings on the basis that they have a vested right in the proper administration of the estate. These are exceptional circumstances, and when the executor is conflicted in challenging his own decision. Want to locate or find information on a deceased estate? Visit the master's website, available on the link on screen and on the description below.